Judge Hamilton made a very important point in appellate judging, which is that we are not just deciding our cases, we are writing precedent, and it's really important when we're writing our opinions to be transparent about what our decision method in the case is and how we get from point A to B to C in the analysis, so that the lawyers and the lower court judges and the public understand the reasoning and rationale behind our decisions. I'm Judge Diane Sykes, and I serve as a circuit judge on the 7th Circuit Court of Appeals. I'm one of 2 Wisconsin judges on the court, and I previously served on the state Supreme Court here in Wisconsin for 5 years and on the Milwaukee County Circuit Court bench for 7 years before that.
I'm David Hamilton. I'm a judge on the U.S. Court of Appeals for the 7th Circuit. Today I spoke with my colleague, Judge Diane Sykes, on methods of appellate decision-making, focusing on textualism, originalism, pragmatism, and broader theories of interpretation.
Most cases come to us with an established doctrine or decision framework for deciding the case, and so it's very often in our cases that these global theories of interpretation won't be debated among the judges or among the lawyers because they're well established in our law, and we as a lower appellate court have the responsibility to follow whatever doctrine and framework the Supreme Court gives to us. But there are some cases that come to us without established precedent from the Supreme Court, and then we're on our own, and we really have to determine based on our views of what the role of the judge is in the individual case deciding function to find a framework of decision for resolving the case. And that necessarily depends on our views of our role as judges as compared to the role of the legislature and the role of the executive branches. And that's where these theories of interpretation tend to come into play.
You usually see reasoning in layers. For example, if I'm working on a problem of statutory interpretation, I will almost always start with the statutory text and then address the parties' arguments and try to reach a resolution if it's possible on a textual basis. But then I'll also turn to additional arguments the parties have made concerning broader statutory context, legislative purposes, evidence of original intentions where that's available and is reliable. And we'll also look at the consequences of the different rules that the parties are looking for. Sometimes the different tools or different modes of analysis will point in the same direction, sometimes in different directions. Then you have to resolve those.
I describe myself as loosely an originalist textualist. So generally in statutory interpretation, I do follow a textualist method of interpretation, and when I'm confronted with a novel question of constitutional law for which there is no precedent, I will try to reason by analogy from analogous Supreme Court precedents and look to original meaning as well, if there is indeed no controlling precedent from the Supreme Court.
I would suggest to you that over time you will see evidence of all these different theories of interpretation from virtually all judges as you deal with just the wide range and complexity of problems that come before us. Certainly you will see judicial writing that endorses one method over another on a more general basis than the case before them. In our court, for example, you have a lawyer has got to be able to make a textual argument about how to get from the text of the relevant source of law to the result he or she is arguing for. It may not be the only argument that they present, but they have to have an answer to that question.
And attorneys should attempt to read some of what the judges have written in prior opinions to determine the judge's philosophical approach to judging. Because in those hard cases where there is no controlling precedent, the priority and weights that the judge gives to different steps in the constitutional analysis or different steps in the statutory analysis may be decisive in the case.
In my mind, the obligation we have to provide a transparent public explanation of the reasons for our decision is by far the most important constraint, far more important than a commitment to textualism or originalism or any other ism that you like in reaching a decision that the public can understand and accept.